Does this image trigger you? The truth movement is designed to evoke such feelings within you. If you are new to my work and familiar with these individuals, you'll likely want to take a seat. Everyone in the image with exposed written on their heads as a reference to the gurus I have previously highlighted in my past shows. After conducting some thorough research, I've uncovered instances of lying, embellishment, or outright fabrication approved to support their claims. I already exposed certain actors here that you can see here, but what about the other ones? KL I've debunked thoroughly, and I won't repeat myself too much on here, but today we got some court cases to review of Mr. Alphonse here. Stay with me. We're going to review some recent court and legal proceedings. The forthcoming video will contain enough information for you to assess, using your own reasoning, whether you wish to continue being part of the truth movement echo chamber or not. I will not be presenting ad hominems, merely evidential sources only. Crow 777 is looked to as the OG of the new legacy alt movement.
She signed it as Rosalind Ray Keenan, beneficiary.
Some of you may know about the sovereign, freeman, tax protester movement. Thousands of people were introduced to the sovereign movement, and it can be credited to this guy. Now, my co-host Clint Richardson was their very first law guest. For those of you who know Clint is a legend. After which the guests got deeper and deeper into the lore, though, the show continued to highlight guests with some big claims, with some reckless strategies that Clint and I have thoroughly proven to be legal fiction. Because Crow 777 has such a wide reach, this gives the guests a lot of credibility, really unearned credibility in people's eyes.
We never wanted to be legal advice either, but I'm glad that you never even tried to tell people that you were giving good advice, because we try to tell people, this is good advice, we checked, we're really stressed out, but use this, right? So we tried to only have really, really good guests on, and I still screwed up with a few guests.
Crow's most favored guests are KL and Alphonse. And let's include Cal Washington in here. All three of which I found to be full of shit. I'll go through why on these guys. First, we're going to focus on KL. Now, Crow has isolated his findings into three categories of the law gurus.
There's pros and cons to all of the three methods that we've categorized through wading through all this stuff, which is the crazy people like me who want to just have a conversation with cops when that's like the last thing you're supposed to do. And then there's people who want to like change their status and be like, I am not what you say I am. I discovered the fraud and I want to figure out a way to step out of this and separate from this beast system and just not be a part of it. And then there's people who want to go into the system, use its rules that are already in place and try to get money, change legislation, punish people by putting them in jail possibly, or just protecting themselves from another human being that has done them wrong in this current system that we live in. All of them can sometimes mesh together.
Look, guys, it's all bad. You cannot change your status and think that's going to do something for you. I'm not going to repeat myself too much. We've covered this in nauseam on past shows, and I highly recommend that if you're stuck on the whole status thing still, that you watch this episode of Red Pill Sunday School. I'll give you the quick highlights, though. go through things that these various status change groups like state nationals, non-citizen nationals, State of the Union nationals, pre-1933 state nationals. I'm going to go through things that all of these groups don't want you to know. Now let's first start out with USC 8, subsection 1408. Non-citizen nationals codified as U.S. possessions. USC 8, subsection 1101, subsection 821 through 822, describes nationals as a citizen and a U.S. possession of the nation state. But if we actually look in section 101A 22 INA, the term outlying possessions of the United States is defined in section 101A 29 of the INA, and here it says as U.S. possessions as American Samoa and Swain Island. No other statutes define any other territories or any of the states as outlying possessions. So no, you weren't born in the Swain Islands. You weren't born in the Samoa Islands either, okay? So, no, you cannot legitimately say without defrauding the office, the passport office, that you are in fact a legitimate non-citizen. And even if you are, here it says you're still a possession of the nation state. 22 CFR subsection 51.7a, passports are personal property of the U.S. government. So yeah, a lot of them brag, oh, I have this passport that says I'm a non-citizen. Yeah, your passport is a possession of the U.S. government, which you say you are not part of. And then in the INA, we got section 34985. U.S. citizens cannot renounce their citizenship through the mail. That's what these guys have you do. You cannot renounce your citizenship through the mail, through an agent, or even being present in the U.S. Renunciation will not have any effect on your U.S. tax or military service obligations. It will not allow you to avoid possible prosecution for crimes you committed. And a perfect example of that is, well, one of the gurus of the state nationals, David Straight's wife, Bonnie Strait. Guys, she is in prison. Remember how they said they have the special do not detain status as a person who's changed their status, right? What the hell is she still doing in prison? It's been years, folks. They have no proof of court case winnings based on their status, or by any of the gurus like David Strait. The only proof we see are failures. And no, they're not hiding behind some NDA. Like we've gone over before, you would still be able to find the docket and all that, even if it was a sealed case, right? Which, in sealed cases, they don't make you sign an NDA, so that is another false thing. Why have people that gone through the state national process, one of the guru's wife, Bonnie Strait, why have they been arrested? Why are they in prison? And then we got INA 349A5. You have to renounce your American citizenship by going to a U.S. consulate embassy to renounce your citizenship. And I guarantee none of you have done that claim to have changed your status. Look, I don't know what else to tell you guys. Do you need any more proof to see that these status change gurus are absolute frauds? But anyways, he thinks he has done the due diligence on the alt-law movement. Now, Crow has his preference, the KL route. And KL is one of the status change type gurus. Now, KL is a guru seen as the final boss of sovereign law gurus by fans. But I recently proved KL is full of shit. I made a video highlighting problem areas people who reached out to me using KL's process were running into. Then KL and his buddy Rice made a rebuttal video in response to me.
You can dictate the court proceedings and what kind of judge you're going to get and what kind of rules they're going to play by. And it won't be the regular rules because, again, trusts are a special thing.
The so-called pure trust, also known as the constitutional trust or the common law trust.
When we write these trusts and we send them to the government, we give them 30 days to disclaim. So we give them the opportunity to say this is fraudulent or this is wrong.
The IRS determined that the trust should be disregarded.
Brandon did mention that he tried to read Art of the Passing Buck, Book 1, and he dismissed researching who these individuals behind the trust were that wrote the book.
Imagine being the guru saying all this, and then you're literally dealing with what you said wasn't possible.
They defended that book against the IRS, and I believe the Department of Defense.
The IRS determined that the trust should be disregarded. The total amount of tax deficiencies assessed in these 4 cases involving Wyckoff and Ozak's promotion of common law trust is
just register everything in the trust and there isn't going to be a problem. When you don't have to pay taxes and you get 100% of your check, boy, let me tell you, that's a whole different game.
That's a whole different game.
And this is a real life example of someone trying to do this.
I can't tell you how many issues I've had with clients that have set these up, that have bought properties with them, they go to sell them, no one knows what the hell it is. The title company's like, what is this? This state doesn't have business trust. I know it's a Delaware business trust. Okay, but you're in California. They're like, yeah, we don't recognize that here. They wouldn't transfer the property. The person had to unwind the whole thing, deed the property back to the person they bought the property for, have them deed it back to them.
So when you ask an attorney, they're probably going to say, I have no idea what you're talking about. That doesn't make what I'm doing wrong.
Hale often says, well, court cases are implied trust. Become trustee and make yourself beneficiary. But here we go. If you actually look at the legal definition, there is no trustee in a constructive trust. So you're talking about a trust that would be administered by a court. How is that private? All right. Or even, how is that in your control? A citizen of the United States is a civilly dead entity operating a co-trustee and a co-beneficiary of the PCT, the Private Constructive Sesquive Trust of the U.S. Inc. So there he goes. He tries to use a constructive trust, which we've gone through that. It's not what he's talking about at all. It's on the congressional record that the straw man is in a trust. Sesquive Trust of the U.S. Inc. under the 14th Amendment, which upholds the debts of the U.S. and U.S. Inc. It's on the congressional record that the straw man is in a trust. If someone is using 10 explanation points, that makes me even more skeptical, right? So it's like he's trying to use these explanation points so that you don't actually go and read the congressional record that he's quoting. So you pull this congressional record up, June 13th, 1967, page 15641 through 15646, and nowhere does it mention it all the straw man. It doesn't mention trust or that the straw man is a trust. It doesn't mention any of those things. Did anyone bother to actually go and read this? What the fuck? I pulled it up and it had nothing to do with anything Kale was talking about. And here, guys, I was actually giving Kale more credit than is due to him because this congressional record doesn't seem to actually exist. Now, what I pulled up in my last KL video was something I found on a sovereign guru type website, okay? I couldn't find it in the actual congressional records. So who's to even say that this is real? Because you go on the congressional records website and you can't find this anywhere. And on one of KL's videos with Rice, a friend of the show actually asked a good question. Hey, how come you can't find this? There is no records of this. And Rice had said, well, you're going to have to ask KL about that. Isn't that interesting? He always has to fall back and depend on this KL guy who cannot prove anything he says. So he makes you read books like Art of Passing the Buck, a book by Steve Emerson, and Von Rice that are full of legal fictions and have been scrutinized in court.
because it's part of the prerequisites. Book has information lifted. I have reasons to believe that what she's doing is not helpful. Anna von Reitz.
All these, I think Anna von Reitz and her ilk, I think that these people who are taking advantage of people who are, you know, they need to be made an example of.
So I'm like, oh no, if David E. Robinson's book has information lifted from Anna von Reitz, then that's really a shame, because I am recommending that book because it's part of the prerequisites required to become a student of KL.
Brandon did mention that he tried to read Art of the Passing Buck, book 1, and he dismissed researching who these individuals behind the trust were that wrote the book.
The IRS determined that the trust should be disregarded.
They defended that book against the IRS, and I believe the Department of Defense.
Both because the trusts were sham arrangements with no economic substance, but also because they were grantor trusts whose income was taxable to Mr. Wilson individually. Notice that they called it a grantor trust because the grantor still controlled it, being the trust manager. All right, and then the IRS, they calculated the tax liability. It was tons of money. As of April 30th, 2010, the total amount of tax deficiencies assessed in these 4 cases involving Wyckoff and Ozak's promotion of common law trust is $1.192 million. And then we get to the permanent injunction. So there you go. I don't know how you could call that a win, but I guess I got to do better research, right?
When we write these trusts and we send them to the government, we give them 30 days to disclaim.
Now, another one of the books that KL recommends is a book from this group called Weiss. And I've covered Weiss, the Weiss group, in my previous KL video. And the cliff notes are this. Okay, so Weiss and Associates. What is this? Well, it was founded or ran by a guy named Stedman Jackson, who's now gone. Okay, so these guys allegedly operate out of France, although there is no proof of that, and it actually is very in tune with the sovereign citizen movement gurus. They're pushed by Bobby Lawrence, David Straight, KL. So, what does this group say? Well, they say that they purport to help clients permanently leave the U.S. tax club. They say they will help you file a petition in the U.S. tax court and guarantee 100% that they'll win you a dismissal or money back. They claim a dismissal allows you to no longer have to pay income tax. Now, first, they guarantee that a dismissal for lack of jurisdiction in the U.S. tax courts and claim that this means they can't tax you. But they're selling this to people who have never read a legal opinion in their lives. Well, because they're not easy to grasp. They even link one of their dismissals. What these clients don't understand is the dismissal means that they lose. The linked document literally says something like dismissal for lack of jurisdiction for failure to file correctly. But for every 10 people that understand that, I'm sure that one person does not. They are no different than any other abusive trust guru selling packages, okay? They think getting a petition to the tax court dismissed is a win against taxation. Well, I hate to say it, they are selling dreams, as great as it sounds. They sell the dream that not one document is sufficient to confer jurisdiction over the court. That sounds great to people who don't know how tax court or the IRS actually works. Of course, jurisdiction, a notice of deficiency, is not the same thing as the IRS jurisdiction to go through the assessment and collection periods of an audit. If you try to go to the tax court every time you have an issue with the IRS, that's not going to work because tax court only has jurisdiction to review certain IRS determinations, like notice of deficiency and determination after the collection due process hearing, if you follow proper timelines and procedures. So gurus like Weiss Or others selling the dream that they have the secret way to get a court judgment that displays IRS has no jurisdiction because they file a sham petition and then trick people into thinking the dismissal means they win against IRS, when it doesn't mean that. They also sell the revocation of election paper, which Clint and I covered in our last video. ROE does not work in the context of what these gurus are talking about. Not a single one of the gurus pushing the revocation of election with the IRS ever seemed to have any evidence that the IRS accepted their revocation. And the only proof of success has been claims from people that they haven't heard from the IRS ever since they sent the IRS the ROE. But that isn't proof of anything other than how slow the IRS. And it appears
we've also talked about how the reason they send it to certain offices is because the workers are not allowed to say, "Hey, oh, this is obviously fraud, I'm going to put it aside." They're required to file what you send them. So they say, don't send it to the proper office because they'll actually challenge it. No, send it here where they know it's going to get filed. It's going to go into some file and it's not going to be found for 5, maybe 1, but probably 3, 4, 5 years, maybe 10 years, when all of a sudden you get this massive tax lien on your property and they take your estate to pay for what you did 10 years ago that was completely fraudulent. It's either that or go to jail or right. So the important part, as I said, is they tell you to send it to a certain office because they know that particular agent that you're sending it to has no power to challenge it. They're required to enter the paperwork without question, and they don't touch it again. It's gone until someone finds it later on, right? And then they tell you, well, if they don't respond, then it's such bullshit, man.
It is. And it actually appears the IRS is starting to clamp down on this revocation of election. Some people I have been informed that did this, who sent the Form 56 revocation of election, received from the IRS was called a 3175 letter from the IRS warning them that correspondence they sent is based on frivolous tax arguments, which the IRS has a whole page on. Just look up IRS frivolous arguments, okay? And then in this letter from the IRS, they tell you that the IRS will not respond to further correspondence making frivolous arguments, and in that IRS failure to respond means that the IRS aggressor accepts or acquiesces to such arguments. So if you were to send a revocation of election letter for a collection due process hearing or an offer in compromise, this document could be penalized by the IRS for $5,000 as a specified frivolous submission. Okay, that's what they call it under our IRC section 6702. So the IRS sending a 3175 notice in response to a revocation of election letter, in the IRS's perspective, that establishes evidence that you were warned that your Form 56 letter is, frivolous. And so the IRS, they're going to penalize these documents without warning or giving you a chance to withdraw the frivolous document to avoid the penalty. So just realize the can of worms you're opening if you try to mess with this stuff. You see, the fundamental flaw with the revocation of election, ROE, approach lies in the inability to rescind a choice that was never formally made. Even if the IRS were to recognize an ROE as evidence of non-resident alien status, this designation alone does not grant immunity from tax obligations. Establishing non-resident alien status through an ROE, even if feasible, does not equate to exemption from income tax, as outlined in IRC 871. A legal precedent, Walby versus United States, the court found that the plaintiff, Walby, failed to prove her non-citizen status, dismissing her complaint due to the lack of valid claim. Arguments relying on passport renewal as proof of non-citizen national status were debunked, as the State Department's letter explicitly stated that Walby would be issued a U.S. would be issued a U.S. passport affirming her U.S. citizenship. So it's crucial to recognize that challenging the IRS's jurisdiction, especially during collections, is impractical. The focus should shift to addressing the actual tax liability, evident through ongoing collections activities. So you wouldn't be in the collection period if they didn't have jurisdiction in the first place. I mean, make that argument make sense. So claims of lacking jurisdiction do not negate the existence of tax obligations that warrant collection efforts. Okay, so here we got a IRS response to a revocation of election letter. But if we look at the letter, read what it says, notice it starts off by saying, "Dear taxpayer." The IRS starts this out by saying, quote, "We reviewed the information you provided and determined no action is necessary on your account," end quote. So notice they said you were a taxpayer, and nowhere in this letter did they say the taxpayer doesn't have to file. A revocation election will be used against you as evidence later in tax court, which we've seen happen to plenty of people. And the IRS will send you a letter saying that this is frivolous, the ROE. You're literally walking into a trap with that, guys. Yeah, later in this video, he divulges his favorite gurus that he learned from. He says, "I learned from Winston Shrout, Robert Menard, Brandon Alexander, Gordon Hall, Eric John Phelps, Dean Clifford, and his brother." Winston, all you gotta do is look up Winston Shrout fraud, the rise and fall of a sovereign citizen guru. Look at this. Office of Public Affairs, fugitive and tax fraud promoter captured and set to serve his 10-year prison sentence. United States Department of Justice. Gordon Hall. Hall versus United States. Look at this, guys. Does this look like this guy knows what he's doing? Alright, now he mentions Eric John Phelps. Let's look at this case. Pro se plaintiff Eric John Phelps initiated this action by filing a complaint on January 13, 2022. Okay, so this is pretty recent. Against defendant Secretary of the Treasury, seeking, quote, "a full accounting of all trust property administered by the Secretary of Treasury trustee being held in the name Eric John Phelps," all caps by the way. Federal ID number blah blah blah. The trust, document 1. After paying the required filing fee, Phelps filed 3 petitions and motions to seal this case. Phelps also filed a motion for the court to order service of process by a marshal of the United States, and a motion for the court to send article-free judicial power to provide civilian due process of law in old American exclusive equity jurisdiction and chambers. It's just like KL was talking about earlier, right? And this is a real-life example of someone trying to do this. He says, "For the following reasons, Phelps' motions shall be denied." So guys, you just got to read this case and see that not only is one of his favorite mentors that he supposedly learned from, it doesn't know what he's doing, but also proves everything that KL is saying about Article 3 and Court of Equity. It doesn't work. Motion for the court to set in Article 3 judicial power to provide civilian due process of law in old American exclusive equity jurisdiction chamber. Alright, so look at this. Phelps versus John and Jane Doe's 1 through 99. Cause of action: 42 U.S.C. Section 1983 Civil Rights Act. Now, a lot of these gurus love to use this as a cause of action, as if a lot of these things are civil rights cases when they're not. I mean, he's tried it multiple times. Does not work. And then Dean Clifford, do we really have to get into that? The guy who's been arrested multiple times? So I think I have some background for some ability to do these kind of things. That's a quote from KL.
And KL is like the one guy that his process I don't know, but Crow went through the process and is happy with it and has endorsed it, which is massive. So I'm sending hundreds of people his way, and he's just one guy. And some people haven't heard back from him in a month even. So I have to tell people, it's up to you if you want to do this, but just know it's just one guy. And you might have to wait, and you have to read a lot. One of those books is David E. Robinson. So I went to Crow and I said, "Crow, I did not read this book. And so I don't even know if this book that I'm sending a link to is going to help people or hurt people or make them spell their names wrong, what do I do? And he just says, this is trust law.
He tries to say that his private business trusts are unincorporated business organizations. That type of strategy failed Art of Passing the Buck authors.
I can't tell you how many issues I've had with clients that have set these up, that have bought properties with them. They go to sell them. No one knows what the hell it is. The title company's like, what is this? This state doesn't have business trust. I know it's a Delaware business trust. Okay, but you're in California. They're like, yeah, we don't recognize that here. They wouldn't transfer the property. The person had to unwind the whole thing, deed the property back to the person they bought the property for, have them deed it back to them.
So when you ask an attorney, they're probably going to say, I have no idea what you're talking about. That doesn't make what I'm doing wrong.
My trust is not under federal or state jurisdiction and statutes, codes, blah, blah, blah. How could he argue that successfully in court? And the answer is he can't. Where's the proof that this has worked? Okay, so I was reading through South Dakota trust laws, and it says here, the legal system in the United States, including South Dakota, is based on English common law, and trust law is a matter of state law. Gurus has spun the statutory and public trust thing into an artificial pain selling point. And it's a false binary. Their spin of the public and private statutory trust. Public trust, an organization that manages money for a particular charity or group of people who are poor in need of help. Yeah, again, that's a charitable trust. That's a public trust. Not what these groups are saying. Private trust, a legal arrangement in which you give a person or an organization the right to manage your money for the person or group of people that you have chosen to receive the money. Definition of a statutory trust. A statutory trust, or oftentimes referred to as a business trust, several jurisdictions impose a control test to determine shareholder liability, i.e. personal liability is imposed and the trust is disregarded. When shareholders exercise too much control in the management of the trust, which, again, these guys teach, common law business trust fails, and shareholders will not be entitled to limited liability. Several statutes in the Delaware Code include the term business trust in definitions of person, just like any other state. Statutory trust, let's look at the definition of that. So there we go, an instrument in the filing of a document with the Secretary of State. Again, private trusts don't file with the Secretary of State. So that just debunks these gurus saying, well, if you don't use me, you're going to get a public trust, a statutory trust, and that's, you're going to have to file, blah, blah, blah. Again, here's telling you what a statutory trust actually is. It's not what these gurus are saying. Now, a Delaware statutory trust is a legally recognized trust that is set up for the purpose of business. It may also be referred to as an unincorporated business trust or UBO. So there you go. Remember how he tries to say that his private business trust is an unincorporated business trust? Well, if you actually look at what unincorporated business trusts are, UBOs, they're referred to as Delaware statutory trusts. They're one and the same. So guys, this is an example of cognitive dissonance. They tell you to forget what the laws, the codes, the statutes, and the courts have to say.
Not liable for any state code, statute, or act.
Everything in here is about trust. I mean, maybe there's something, not everything is perfect. Maybe there's a mistake here and there that just a dude who wrote a book, for whatever reason, this is the prerequisite that KL, what if the first assignment with KL is say all the things in this book that are bullshit and that are, and what things are true? You know, who knows? I need to ask him. So that's why it's like, okay, in our official like recommended book list, it used to be just books that Crow actually read that are his favorite books. And then slowly that list has grown to be books that guests have said that they liked. And I haven't necessarily read those books, but I really love that guest, and all the information they always bring to the table is so helpful. And then people are going to also be like, hey, this guest said this book. What's the link to that book? So what am I going to say? I haven't read that book. I'm not going to give you a link to it because if I haven't read it, then you can't. No, I'm going to give them the book that the guest said on the show.
Hey guys, so after digging through Alphonse's legal cases, I found this in his county records. Now, I redacted some of the information because I do not desire to dox him or his wife, so I will keep his personal information private, but I will show enough information for you to be able to see that of what's all going on with his property, all right? So as you can see, his name's right here. That's already public, so I don't mind sharing that with you guys. But look at this. See here it says property type. Now look at that. It says taxable residential. Remember, guys, how he says he is not a taxpayer. Now, he also did not claim his personal residence to be a homestead. So if he would have considered it to be a homestead in a legitimate way, which is a legitimate thing you can do, you can get out of property taxes somewhat with that. So looks like he didn't do that. Okay, let's keep going down. Again, I blurred out a lot of the information because I'm not trying to dox him or the former owners of this property. Okay, so here we go. So county tax receivable. So now we're looking at the tax bill that he's delinquent on. All right, so let's scroll down here. It's going all the way back to 2020. Delinquent tax, all years combined. All right, so yeah, now you can see that they're summing it up here. Wow, so, and then other fees, 158. So in total, almost $15,000. Let's keep scrolling down. Now this excludes trash and sewer and other local fees. I know he was fighting the sewer thing for a while. And he's trying to say that I'm not a taxpayer. And we'll later go through, well, dude, you are using all the privileges that come with that, the city water, like all that stuff, while at the same time saying you're not a taxpayer, right? So if we keep scrolling down, now it says tax sale information. Oh, what's this about? And then the status says listed for upset sale. Wow. Well, I'm telling you, this is definitely making somebody upset. Look, if you guys don't know what an upset sale means, in Pennsylvania, this means that the county is going to list his house for auction for the highest bidder to buy. And when I pull up the upset sales info in his county, it looks like the upset price sale is starting in September 19th of this year. All right, so that's coming up in a few months. Registration is limited to the first 120 bidders and will close once 120 bidders are registered. Interesting. All right, so I pulled this up online, and I highly encourage you guys to look at this yourselves, all right? But I highlighted and we'll sum it up for you. So as we can see here, this is Alphonse versus his township, all right? Okay, July 29th, 2021, the request was filed stating, provide the required business license and or franchise license the persons doing business as the Township of Ashton possess and rely on to charge business privilege and mercantile taxes to either requester and or his property, known as, and that's his address, which I redacted, in Ashton, Pennsylvania. All right, so down here we can read, the request begins by notifying the township that a contractor collecting taxes for the township filed a municipal claim against the requester, which he claims was in error for various reasons. The request demands that the township remove his property from the tax roll. Oh, he got that from Mr. Steve Emerson, didn't he? Because supposedly Steve Emerson brags that he knows how to get your property taxes off the tax roll. If you guys don't know what tax roll means, that just means all the properties listed in the county that are taxable, like we saw in Alphonse's county records. Or in the alternative, fulfill his RTKL request. Okay, so this is Alphonse's demands that he filed. Provide a record containing a list of the business privileges and mercantile services that are being conducted at his address. Look, so that is Steve Emerson's main argument. Well, look, this property is not being used for commercial purposes, so therefore you can't tax me. And guys, we'll later go through that whole thing he fabricated, all right? That's not how this works. Provide a record of any contract, agreement between the requester and the persons doing business as the Township of Ashton, which evidences that there is a contract with the township to administer his property, known as, and his address again. All right, so keeps going. All right, so basically his main argument is, hey, I'm not doing commerce on my property. I'm not a business, blah, blah, blah. I'm not taxable. Provide a copy of the insurance policy responsible for indemnifying the Township of Ashton. which is pretty easy for them to pull up, right? For the actions taken by Pearson Hughes. Oh, okay. Sounds like the law firm that they use. And I remember him saying, well, because they use a law firm, this is all illegal. On behalf of the persons doing business as the Township of Ashton. All right, so he keeps going with this. Neither the municipality nor their law firm possesses judicial power or authority to execute and sign liens of their own accord, but yet they did just do it, right? Nor does the clerk of the court for Delaware County Court of Common Pleas possess judicial power of authority to execute and sign liens. So there he goes again with that. Provide me a copy of all records the municipal corporation doing business as the Township of Ashton relied on as authorization to lien. All right. The township largely denied the request, arguing that no responsive records exist, but did answer the questions posed in items 1 and 4 of the request, and provided the insurance policy responsive to item 6 of the request. Remember, he was asking, well, where's your insurance to indemnify you? The township has sued him for mercantile and business privileges taxes, and that the township is acting illegally in various ways. Okay, so that's his claim, right? The township submitted a position statement arguing that most of the requests to seek legal opinion rather than documents, but that the township has no responsive documents as it never assessed business privilege or mercantile taxes against the requester, right? Of course not. The township also provided a copy of his general liability coverage policy for 2020. All right. So, of course, they don't have records of assessing business privilege. No, he owns his property in his name, the straw man, right? Even though they say that's the natural person, which is sovereign. All right, so let's keep going. By the way, if you own your real estate in your name, and you don't have equity stripping in place, well, you have no asset protection, you have no lawsuit protection, and if something happens to you, your stuff is going to go to the probate, meaning that it's going to go to the government. And then after they sink their teeth into it, then they'll decide to give a piece of it to your family after they tax it and all this stuff, right? Years of waiting. The documents submitted by the requester show a municipal claim made against him, which the receiver contends must be mercantile and business privilege tax because those are only taxes the township can levy. The appeal does not challenge the township's responses to items 2, 3, 5, or 6 of the request. Therefore, those issues are waived, and the OOR will not address them on appeal. Right, so this stage of the case is him trying to appeal all of this that already happened, right? The tax lien, all of that. So let's keep scrolling down. The township argues that no additional records responsive to the request exist. In support of this argument, the township submitted the affidavit of Miss Pippin, who attests that, and here she goes just saying, yes, I work for the township. Yes, I do this. I am an open records officer. Okay. So, right. The township argues that no additional records responsive to their request exist. Of course they don't. And Alphonse is going to say, well, look, that's the victory right there. Look, they just admitted it. After conducting a good faith search of the township's files and inquiring with relevant township personnel, I identified all records within the township's possession, custody, or control that are responsive to the request and provided them to the requester, right? In the absence of any competent evidence that the township acted in bad faith or that the records do exist, the averments in the affidavit should be accepted as true. The thrust of the requester's argument in this case is not that the business tax records sought do exist, but instead that the property taxes assessed by the township are illegal. Oh, so now he's trying to say the property taxes assessed by the township are illegal. All right. Interesting spin on that. The township has submitted evidence showing that it conducted a search for real estate taxes associated with the requester's properties and provided the records which it possesses. The requester did not present any evidence contradicting the township's evidence, and his argument that the township has misapplied the law is not evidence that additional records do in fact exist. All right, guys, so here's the conclusion. For the foregoing reasons, the requester's appeal is denied, and the township is not required to take any further action. This final determination is binding on all parties. Final determination issued and mailed. All right, guys. So I'm going through the case he filed. So Alphonse versus County of Delaware. All right. And you guys can look this up. Here's the case number. This was last year in 2023. Now, I find it funny because in a past video where I was highlighting a guru of KL in a court case, he used the same cause of action, civil rights violation, 42 USC and Civil Rights Act. Guys, this is not a proper cause of action, and this has nothing to do with civil rights. And if you think civil rights and claiming this as a cause of action is a remedy, well, as we've seen twice now on this show, it does not work, folks. All right, so we can start from the beginning, but let's just go to the final filing here, okay? So, as we can see, Alphonse just keeps filing things. He demanded a trial by jury. A complaint against Susan Brockett, County of Delaware. Okay, so that's a worker at the tax bureau. Look, I'm sure these tax bureau people are horrible people. I'm not sure what type of person would be attracted to work at some sort of thing. But at the same time, if you're going to go against these people, you better come correct, right? All right, so let's see if he does. Filing 6, summons returned executed by Alphonse. Oh, we got Brett Fountain here. Isn't this Patriot Brett or whatever he calls himself? I know he doesn't like to show his last name, but here it is. And these two are supposedly the best at court procedure, right? First motion to dismiss for lack of jurisdiction pursuant. Okay, so this was filed. So then they just keep filing responses to dismiss. And then the other side files motion to dismiss. And just keeps going and going and going. Well, guys, as you can see, I don't think it ended well. Okay. Look, we have the upset sale listed here. It's going up for sale to the highest bidder here coming up in September of this year. So keep an eye out on that. Friend of the show that will stay anonymous has a great blog that I think you guys should check out. He has very thorough articles here. Now, I highly suggest you guys start out with this one. Beware Patriot Mythologists, Part 1. And it starts out with this. Alphonse, one very common misconception that is arrogantly promoted by Alphonse Falgiolo is the idea that the citizen is sovereign. Here are a few statements Alphonse has made in his Telegram channel, promoting his misunderstanding. Let's dispel another two myths. Number 1, citizens are under the jurisdiction of the government, and if you identify yourself as a citizen, the government has jurisdiction over you, and you will lose rights. And number 2, civil rights are for citizens, and man has natural rights. Isn't that interesting he said that? Civil rights are for citizens, and he's really shitting on citizens here. But remember in his cases, his cause of action was civil rights. All right, so obviously he changed his mind down the road. Both points are completely untrue. And I'm not sure where these myths came from. Well, I think the author of this does know. It's from the outlaw guru space that's been going on, like I said earlier, since the 19th century, right? But I know they're perpetuated by the Patriot mythology crowd. Okay, so he does acknowledge that. There's nothing wrong with being a citizen, regardless of what people have told you. That's what Alphonse says. I've heard him say that. Calling yourself a citizen doesn't hurt you in any way. Now, this blatant falsehood that Alphonse has been spreading is rooted in his misunderstanding of his statement of the Supreme Court in Scott versus Sanford case. Did Scott versus Sanford say that citizens are sovereign? The words people of the United States and citizens are synonymous terms and mean the same thing. They are what we familiarly call the sovereign people And every citizen is one of this people and a constituent member of this sovereignty. Scott versus Sanford. Folks, remember, like our friend Clinton Richardson says,
what I want you to understand first is talking about sovereignty. What is the maxim of law? And this killed it for me. I never will ever think myself or anybody else as a sovereign except for a king who declares that. And that is simply this. A sovereign, to be a sovereign, you have to rule over other people.
Yep.
What the hell is a king without subjects? What is a sovereign without people to be sovereign over, or land or anything else? You're not sovereign, folks. You are not sovereign. Now, the state, which is another word for people and state are the same word. We, the states, yeah, those are semi-sovereign entities, and that's what we're actually kind of going back into is the state constitution, the state law, the private side. That is to be part of the people, part of the state. But don't ever think that you are the people, because people is plural. Person, the plural of person is persons. Persons aren't people. The people is the state. The state is represented, so we, the people, are actually the Senate, because that's who we put up to it. So any idea that you have, anyone that tells you you're sovereign, there is only one, you should have only one sovereign, and that is God on high. That is your sovereign. That is where your law comes from. Everything else is man-made. All sovereignties, besides Jehovah, YHVH in the Bible, is false. It's artificial. It's a false god.
and here, Scott versus Sanford says something very different, clearly, than what the mythologists will tell you. The support for this interpretation comes from Black's Law Dictionary, 4th edition. Sovereign people, the political body consisting of the entire number of citizens and qualified electors, who, in their collective capacity, possess the powers of sovereignty and exercise them through their chosen representatives. I mean, guys, I can't believe my friend here has to go through all this with you guys, right? I mean, shouldn't this be obvious? Sovereign, in this case, is not talking about you and I as a natural man or woman, right? No. They're talking about the nation state. The nation state is sovereign. You are not the nation state, right? Can a citizen ever be sovereign? Now, we have been told that each state being sovereign are all equal. So each man is naturally a sovereign over himself, and all men are therefore naturally equal. Can he, man, retain this equality when he becomes a member, citizen, of civil government? He cannot. As little can a sovereign state when it becomes a member of a federal government. See, there we go. He's talking about the nation state. This is from James Madison, one of the founding fathers that a lot of these patriots romanticize. But guys, when they're talking about we the people, that little document you guys worship, they weren't talking about you, were they? Now, let's look at a few definitions from the Law Dictionary to aid our exploration. Here's how Black's Law Dictionary defines citizen. Citizen, a member of a free city or jural society, possessing all the rights and privileges which can be enjoyed by any person under his constitution and government, and subject to the corresponding duties. So see, there we go. Now remember, Alphonse says he's not a taxpayer, but yet he still uses all of the privileges that come with having a house in the county. Look, if he was roughing it in an unincorporated township, let's say, he wasn't using any city water, none of that. Well, I guess maybe he would have like a spiritual case there. But guys, as you can see here, a member of a free city or jural society possessing all the rights and privileges which can be enjoyed by any person. It's just like what I was saying earlier about these sovereign people who say they are a natural person. And they think that gets them out of all this stuff.
And Brandon, I'm going to give you something to actually look up. Pollock v. Farmer, U.S. Supreme Court, 1895. All where they ruled that there's a difference between a natural and a private person. Because what they tried to do in 1895 was tax the man and woman for income taxes. And the Supreme Court said you can't do that. You cannot tax a natural person, but you can tax an artificial person like a corporation. Okay?
Natural person describes a natural human being, which, I mean, they can call it that, but that's the straw man. Artificial person describes a partnership, corporation, or some other entity that has been provided with legal personhood by statute. Which, again, the alternative movement is terrified by the sound of this. When, in reality, if you're a smart business person and smart investor, you want that separate person. So he's trying to say that the straw man is a corporate soul, right? And that's, again, he just lists a Supreme Court case.
Clint and Brandon, I'm going to give you something to actually look up. Pollock v. Farmer, U.S. Supreme Court, 1895, all right, where they ruled that there's a difference between a natural and a private person. Because what they tried to do in 1895 was tax the man and woman for income taxes. And the Supreme Court said you can't do that. You cannot tax a natural person, but you can tax an artificial person like a corporation.
His argument, Pollock versus Farmers Loan and Trust Company, 1895.
And there was another gentleman, I get on the phone with them. It's always somebody that they say is a lawyer, but it's not a lawyer.
Yeah.
They know a lawyer, and the lawyer had a Supreme Court decision that they rely on when they said to do it. And I'm like, what's the Supreme Court decision? And then I look at it and I'm like, it has nothing to do with what you just said.
Yeah.
You know, or it's something that is like from 1800s or something goofy where you're like, you know, or a long time ago, 100 years ago.
Sovereign people who say they are a natural person, they use all the same privileges. You drive on all the roads, you use the Federal Reserve notes, you use their banks, you do all of that, right? So you are definitely enjoying the rights and privileges that are enjoyed by any person under its constitution and government. But yet you're saying at the same time that you're not. The term appears to have been used in the Roman government to designate a person who has the freedom of the city and the right to exercise all political and civil privileges of the government. There were also at Rome a partial citizenship, including civil but not political rights. Complete citizenship embraced both. Okay, so that's interesting. Now that reminds me a lot of, especially Crow, he will pose the question all the time on his shows. Look, is your name in all caps? What does that mean? It's a Socratic question, right? Kind of like Q did. They ask questions that make you think, oh, what does that mean? And of course they're going to say, well, your name is all caps. That means you're a corporation. Guys, like we've gone over in the show before, there is nothing special about your name in all caps on government IDs, okay? Or paperwork. Do corporations, when they're listed, are they in all caps? Usually, yes. But look, the all caps thing is a styling technique that goes back to the Roman government that's described in here. There's nothing special about your name in all caps, folks. Neither is writing your name in a Christian name format or all lowercase. It doesn't work. A member of the civil state entitled to all of his privileges. Alright, so let's keep going. Natural rights are those which grow out of the nature of man and depend upon personality, as distinguished from such as are created by law and depend upon civilized society. So from such are created by law. So these people are trying to say we have natural rights, but yet it's created by artificial law because the legal system is 100% artificial. But yet you try to go in the artificial system and say that you, inside of it, in its room or documents, are the natural person. Upon civilized society, or they are those which are plainly assured by natural law. Civil rights are rights appertaining to a person in virtue of his citizenship in a state or community. Remember that. Remember, Alphonse, cause of action was civil rights violation. Civil rights, Title 42. He says he's not a taxpayer. He's not responsible for all the county stuff, but here we go. Civil rights are rights appertaining to a person in virtue of his citizenship in a state or community. Allegiance. By allegiance is meant the obligation of fidelity, interesting word there, and obedience, which the individual owes to the government under which he lives, or to his sovereign, in return for the protection he receives. The citizen or subject owes an absolute and permanent allegiance to his government or sovereign, or at least until, by some open and distinct act, he renounces it and becomes a citizen or subject of another government or another sovereign. And guys, when they say sovereign here, don't think it's one of you guys. No. We're talking about a nation state. It's the only thing in this world nowadays with international law set up that can be sovereign. So guys, like Clint has walked through and I have walked through in our past shows, especially with these status gurus, look, you can't say you're not, you don't owe allegiance to the state if you haven't renounced your passport, and you can't do that while you're on shore in the United States. You would have to go to another country, get citizenship in the other country, which takes steps, some more countries than others, and then you have to get that new passport and renounce your U.S. citizenship, which none of these people have done. Oh, well, I get a new passport in the mail because I fraudulently filled out that I'm a non-citizen national. And like we've gone through before in nauseam, you are not a non-citizen if you were born on the States and live in the States. To legally fill that out as a non-citizen national, you have to be born in the Guam Islands or one of those outside islands of the U.S., right? Which, again, the law clearly spells out, yet these people will ignore and throw ad hominems towards me for pointing out the obvious, right? Local allegiance. The measure of obedience which is due from a subject of one government to another government within those territories he is temporarily resident. So a lot of these guys try to say, no, I don't think Alphonse goes down this road, but a lot of the gurus say that, well, because I'm in the state and the state is sovereign, I'm not in the nation state, right? But here that counteracts local allegiance and all the other things we just read, all right? In American law, the allegiance due from citizens of the United States to their native country, and also from naturalized citizens, which cannot be renounced without the permission of government to be declared by law. Look, guys, I certainly don't describe myself as having allegiance to the government spiritually. But look, if you're born in the system, it is assumed because you are using the person, just like we're going through earlier, right? The term citizen, as understood in our law, is precisely analogous to the term subject in the common law. And I hear to the common law idiots, looking at that going, oh! And the change of phrases has entirely resulted from the change of government. The sovereignty has been changed from one man to the collective body of the people. And he who before was a subject of the king is now a citizen of the state, and the state is part of the nation state, right? Just look in any of your state's constitutions and you'll see that very clearly. Remember how Alphonse so boldly stated, calling yourself a citizen doesn't hurt you in any way? Remember how in the definition of citizen, it says that a citizen is subject to certain duties. Well, paying the income tax is just one of them, and also property taxes, all that, right? Following the statutes written by your legislator is another. And look, I know this guy is aware of this, but also myself. Look, guys, I'm not saying just pay your taxes happily. No. There are legal loopholes in the tax code, especially as entrepreneurs, where you can legally not pay taxes, all right? Now, we won't go through that today. That's a whole nother episode. I've already talked about that, right? So if you walk into court and claim to be a citizen and a resident of a state and also claim that you're a physical man or woman, so the law doesn't apply to you because it says it applies to persons, because remember, the alt law movement really spurs out on the whole persons thing. Like, I'm not a person. A person is a corporation. I'm not a corporation. Well, but yet they say they're a natural person, which is a legal person in legal personhood, right? You just contradicted yourself. Go look in any state statute and you will see that reflected. So he is completely disregarding what the law actually says. There is an admission out of your own mouth on the court record that you are subject to the statutes no matter what else you may say to the contrary. What rights do you have as a United States citizen? You've been told your whole life that the Constitution grants you rights or protects you in your rights, and that the Bill of Rights protects you. These are myths that the controllers have taught you to make you easier to control. And honestly, the law gurus also tell you that it's a good thing. All right, so now we got part 2, and this talks about Steve Emerson and Alphonse. Because remember, Steve Emerson is Alphonse's guru in this whole property tax thing. The information presented here will challenge information that you currently believe to be true and have a vested interest in being true. I ask you that you temporarily suspend these beliefs and follow the analysis I present with an open but critical mind. When you finish reading the article, compare and decide what is truth and what is fiction. The following analysis is taken from a document named Florida Property Taxes Essay, written by Steve Emerson. Let's start with Steve's history of land ownership. In the first section of his document, we find this quote. The American people, before developing a properly functioning stable government, developed a stable system of land ownership whereby the people own their land absolutely and in a manner similar to the king in common law England, as allodium.
Can a non-sovereign entity hold a sovereignty or a allodial title over land? No, because the other maxim of law says you, the common people, can never have the power of the sovereign. You're not equal to the sovereign. That's three or four maxims of law. So you start adding all these things together, and it puts you in your place. You don't have this power to overrule or overarch the state. You're counting on that sovereignty within the state to protect the actions that you have while giving you the chance to live a private life under God. But all of the legal stuff stays in the legal realm.
And so what's wrong with the thoughts around patenting your land or getting the land patent, or allodial title has been popular in those worlds? Yeah, please.
No, a good question. I'm glad you asked that, Beth, because that's being pushed out a lot right now. I would say more than ever. And this thing is not new, okay? This thing, I was reading a case about Carol Landy. I mean, she was one of the biggest gurus on land patents back in the 80s, and she got put away. And, you know, we can go into that. But basically, you know, these gurus, they tell you to do a land patent to protect your land. Well, they got something right about the land patent. It's patently frivolous in a strategy in court. And we can see failures of the strategy in past cases.
First of all, coming from medieval Latin, is allodial. What does that come from? Well, it's a feudal term, first of all, coming from medieval Latin. And it really it means, it goes from allode, A-L-O-D, and it means to be above. So you have to understand, when you're operating in the private, the difference between what you're doing is you're going outside of the international law body that controls interstate commerce and that kind of thing. So you're going back to the state. So your state constitution applies. All this, you still get you're not going to avoid anything that the state, private law of the state, the foreign law of the state doesn't have in it. So you can be eminent domain because that's the right of the state. Why? Because the state is the only thing that holds a allodial title. how can you have something? How can you have a right, a private association that comes from the state, to be private from some foreign entity, and also be above the state? How can you have land that is above the state? You can't. That's the maxim of law, where you can't be higher than the king, you can't be equal to the king, you can't be equal to the state, you can't be equal to this false god that is what giving you these so-called rights, right? So one thing you will never hold is a allodial title. You can have things like fee simple and that kind of thing, but it all boils down to, is your land lienable or not? Is your land in a position where a lien can be put upon it? Well, if that land is in a PMA, like he was saying earlier, well, then it's going to be very hard to put a lien on the land if you're suing an individual person who's part of a larger group. How do you put a lien on a larger group, right? So it's a matter of understanding that you will never be above or allodial to the state. You can't. This is it's what's giving you any authority or power to be in this position of privacy. There's that brings up a whole other subject of going in. You got to remember that your foundational state, and I hate to bring this up because it's a large subject, but you got to remember we're prisoners of war. This is a system that's been given to us to use as prisoners of war, okay, from the labor code and all this. So that's a whole other subject, but it's also a very important foundation to understand, which especially puts the patriot mythology to rest. Okay, after the Civil War, when all the land was the public lands were assigned to the United States, and all every state had to form its new constitution. I did a whole series, Red Pill Sunday School, about this, so you want to really know about it, and how the last thing the United States, Washington, D.C. said to, say, Texas, who says, we're a republic, right? The last thing it said to Texas is, if you get out of line again, we're going to beat the crap out of you again, essentially. So we're not in a position, states can't secede because the land is federal. You can't, it would be like stealing land. None of this is true. So you have to start from a position that we're a conquered people. All nation states that are members of the United Nations are authorities that have conquered or purchased, same word for purchase. If we say Louisiana purchase, that means that area of land was conquered, okay, by voluntary purchase or by war. So we are a conquered people. As soon as you come down to that realization, then all of this other stuff starts. Then you understand your limitations. You can't be higher than your captor. You can't be higher than the state. You can't have a allodial title. All this other stuff it comes from a time that I don't think really ever existed, which was a time when all men were free. Well, tell me when men were free if the king owned this land. When was it a free land? I don't understand. When was it free?
Well, and a lot of people get confused about what is a land patent. And you got to go back in history and really flesh out what is a land patent. And so back in the colonial times, there were no uniform conveyances of land ownership. And this went on for a long time. And we didn't start figuring that out until the Brits' ownership of land was null and void after certain treaties. But then even later with purchases and then the conveyance of private lands into federal public lands started to be implemented. And so that's when this land patent started to generate. It was when basically the government was perfecting their land ownership. It's not yours. It was never for the people. It was always for the government's conveyance.
In order to form a more perfect union? You don't think that has a special legal meaning?
I was just hearing, lay it on us. What does perfect mean? It's a commerce term, correct?
Yeah, I mean, to get it right, I'd look it up. But yeah, it's basically you can explain it probably better than I can. you're perfecting you're putting your debts in an international. You're making yourself. You're incorporating basically. It's kind of hard to. I have it in my my video, but I it was a while ago since I looked at it.
You can think of it as a settled manner, basically.
Nice.
And so, yeah, I mean, these gurus, they'll tell you to file a declaration of land patent in the county recorder's office and or office of deeds, but a declaration of land patent is a document filed in conjunction with the original land patent in an attempt to bring the land patent up in the current owner's names and these, people trying to do it nowadays. So in other words, the individual filing the land patent draws up a made-up paper and purports to replace the original land patent holder's names with his own. And the holder then appears to possess a fresh patent from the government because they're only issued from the government. You cannot issue yourself a land patent, when in fact nothing is new. The two documents have completely different functions. And so a land patent is a legally recognized instrument. And when I say that, it was the original one from the federal government, but the legal effect of a declaration of land patent that people try to file nowadays, it's null and void. And so claim to ownership, the original land patent being handed out by the government was really, it cannot be something that you write. Only they can write. And so you cannot just go out there and create your own like these guys are telling you can do.
Mm-hmm. Really good to know. That's awesome.
It wasn't until after this was written that the US did start to have what we now have, the fee simple system. Now, it's not possible to own your land through a land patent anymore or allodial title like these gurus are claiming that you can do. I see no way of solving this question by determining whether our Pennsylvania titles are allodial or feudal. And look, guys, I'm not arguing that this is a feudal system. We have been in a feudal system ever since the beginning, really. This is not new. This is not like some thing that the Patriots just got fixed, right? It's beyond that. You guys, you are the point. You're past the point of being able to do anything about the feudal system. Unfortunately, when it comes to real estate, right? Look, you stop paying your property taxes, they're going to foreclose on your house, right? We know that to be true. It seems strange that so fundamental a question as this should be in doubt as this day, but has never had, so far as I know, a direct judicial decision. In a valuable note by Judge Sharswood to the opening passages of Blackstone's chapter on modern English tenures, it is said that though there are some opinions that feudal tenures fell with the American Revolution, yet all agree that they existed before. So the better opinion is that the feudal tenures still exist. This contradicts the made-up statement Emerson uses in his document. To confirm, take a look at the warranty deed conveying your property to you. Right? If you guys don't know what a warranty deed means, that's the new deed that you get after you purchase a house. That's like the paper trail of a transaction on real estate, right? Does it say the land is conveyed in fee simple or allodium? And I already know the answer. It's fee simple, guys. If it doesn't say anything, go check your state statutes because this is what it was found in Utah. And this is going to be uniform in any other state, right? All the state statutes are uniform at this point. Utah Code 5713, grant a fee simple presumed. Yeah, I've dealt with dozens and dozens of properties, changing titles and all that, doing all that paperwork, warranty deeds, quick claims, whatever we're doing. And yes, this is all done with fee simple. Never have I dealt with a county where they consider it to be allodial. A fee simple title is presumed to be intended to pass by a conveyance of real estate unless it appears from the conveyance that a lessor estate was intended. Alright, so let's continue to the next court quotation in Emerson's document. The American people, newly established sovereigns in this republic after the victory achieved during the Revolutionary War, became complete owners in their land, beholden to no lord or superior, as sovereign freeholders in the land themselves. look, it might have started out like that before we became the nation state with the Constitution and all that, guys. Behold this new Lord Superior as sovereign freeholders in the land themselves. These freeholders in the original 13 states now held allodial the land they possessed before the war only feudally. This new and more powerful title protected the sovereigns from unwarranted intrusions or attempted takings of their land, and more importantly, secured in them a right to own land absolutely in perpetuity. Alright, so pulling the leading fighter versus County of Gregory case here, and just search for the quote, Control F, perpetuity, since Steve highlighted that word in red text. Did you find it? Neither did I. That's red flag number 2. And we didn't get past the first page, so there we go, folks. We already find Steve Emerson making 2 fabrications on just the first page. This is very similar to KL's presentations, which I have gone through, like the author of this blog. Let's skip the rest of the introduction since we know it's garbage and jump down to Steve's analysis of the Florida statutes on page 9. Read closely, as afterward I will get into the key parts of sentences that he omitted to completely change the meaning of words. Florida State Constitution Article 3, there shall be exempt from taxation, cumulatively to every head of family residing in the state, household goods and personal effects to the value fixed by general law. Oh, okay, so just by seeing that, now some of you guys will think, oh, they shall be exempt from taxation. That's talking about me and property taxes, income. No, we're talking about household goods, guys. We're not talking about real estate here. Exemption of household goods and personal effects. There shall be exempt from taxation to every person residing and making his or her permanent home in this state, household goods and personal effects. Title to such household goods and personal effects may be held individually, by the entireties jointly or in common with others. Alright, so Florida Administrative Code. This is all what Steve Emerson highlights as the gotcha to saying supposedly this gets you around property taxes, right? Exemption of household goods and personal effects. Only household goods and personal effects of the taxpayer which are actually employed in the use of serving the creature comforts of the owner and not held for commercial purposes. Oh, so this is where Steve Emerson gets the, well, my property isn't used for commercial purposes, so therefore it's not taxed, are entitled to the exemption provided by section blah blah blah. Alright. Creature comforts are things which give bodily comfort, such as food, clothing, and shelter. And this is, he highlights that in red, alright? Commercial purposes include owning household goods and personal effects as stock in trade, or as in furnishings in rental dwelling units. The Florida State Constitution, Article 7, every person who has the legal or equitable title to real estate and maintains thereon the permanent residence of the owner, or another legally or naturally dependent upon the owner, shall be exempt from taxation thereon. The real estate may be upheld by legal or equitable title, by entireties jointly in common, as a condominium, or indirectly by stock owner. Okay. Exemption of homestead. See, this is what I was talking about earlier. You can claim in some states your property, your primary residence, as a homestead, and that will help mitigate county taxes, property taxes, right? That is a legitimate thing you can do. Every person on January 1st has legal title or beneficial title and equity to real property in the state, and who resides thereon, and in good faith makes the same his or her permanent residence, like I was just highlighting, or the permanent residence of another or others legally or naturally dependent upon such person, is entitled to exemption from all taxation. So right after the above section, Steve provides definitions from Black's Law for the following terms: house, shelter, household, home, comfort, personal effects, and household. Steve uses the definitions from Black's to draw the following conclusion on page 11. As stated above, household goods and personal effects are defined technically as things which give bodily comfort, such as shelter, parentheses, house. That's definitely not true. And that the title to such household goods and personal effects house and the land insists upon, parentheses, used solely for the creature comforts of the taxpayer owner and not devoted to some business or commercial purposes. Okay, here we go. If you didn't know, jumping from the statute to Black's Law Dictionary to determine meaning is a common mistake for a beginner. The courts have a very specific way they interpret statutes, and it is best explained by the court and not me. Quote, the starting point in any endeavor is to construe a statute is always the word of the statute itself, unless Congress, the legislator, has clearly indicated that its intentions are contrary to the words that is employed in the statute. This is the ending point of interpretation. Fuller versus the United States. Okay, so with this in mind, and because Steve is attempting to argue that your house and the land and it sits on are household goods and personal effects, let's check to see the definitions for household goods and personal effects provided by the Florida legislature. Personal property, for the purpose of an ad valorem taxation, shall be divided into 4 categories as follows. Household goods means wearing apparel, furniture, appliances, and other items ordinarily found in the home and used for the comfort of the owner and his or her family. Guys, that should be obvious to you. But again, we have to highlight this because they're going to try to misinterpret what these things actually mean, right? Household goods are not held for commercial purposes or resale. Of course they're not. I'm not arguing with that, neither is the author of this blog. Real property means land, buildings, fixtures, and all other improvements to the land. The term land, real estate, realty, and real property may be used interchangeably. Taxable value means the assessed value of the property minus the amount of any applicable exemption provided under the state constitution. Now, I know you want to believe Steve and Alphonse. I did it first, the author says. We all do. Because we don't want to be paying property tax to live on the land given us by Jehovah. I don't really like the term Lord. But using your prior belief aside, did you come to the same conclusion as Steve when you use the meaning of the terms defined by the Florida legislator? Is it possible for your real property to be included in personal property when they are given very separate and clear definitions? Now, let's analyze this statement from Steve's document. That seems to indicate that if you maintain a piece of real estate as your permanent residence, that you are exempt from taxation on your real estate. Deception by omission. Steve left out key language from the Florida State Constitution, Article 7, Section 6A, that is necessary for interpretation. I will include what is in Emerson's document below, and then include the entire section. All right, so here we go again. Every person who has legal or equitable title to real estate. Again, this is from Steve's little essay he wrote. Maintaining the permanent residence of the owner shall be exempt from taxation. Okay. Here's the full section with the important part omitted by Steve in bold. The Florida State Constitution, Article 7, Section 6A. Again, let's look for ourselves, not believe Steve. Every person who has the legal or equitable title to real estate and maintains thereon the permanent residence of the owner, or another legally or naturally dependent upon the owner, shall be exempt from taxation thereon, except assessments for special benefits. Up to the assessed valuation of $25,000, and for all levies other than school district levies. Remember how we were showing how on Alphonse's property he's delinquent on school district levies? On the assessed valuation greater than $50,000 and up to $75,000 upon establishment of right thereto in the manner prescribed by law. Okay, so if you guys don't know what that means, this is describing that yes, they do have some property tax exemption if you deem your property to be a homestead, which Steve does not teach you how to do. Neither is Alphonse using for his own properties, right? And not all states are that you can do that. But even then, even if you do that, it doesn't get you 100% out of all the property taxes, right? Okay, the key part of Article 7, Section 6A is the first sentence that explains the exemption. I will include it again below with the keywords that give it meaning in bold. The phrase "accept assessments for special benefits" is a parenthetical clause and doesn't change the meaning of the sentence. So we can take it out. Let's see what we're left with. Every person who has the legal or equitable title to real estate and maintains thereon the permanent residence of the owner shall be exempt from taxation thereon up to the assessed valuation of $25,000. Again, homestead exemption limit in Florida. Now, this has a completely different meaning from what Steve Emerson conveyed by omitting that qualifying part of the sentence up to the assessed valuation of $25,000. Yeah, he selectively took words out, right? Here's how the property tax exemption works in Florida. If you own a piece of the real estate that your primary residence and its assessed values $500,000, you will be exempt from taxation on $25,000 of the assessed value. Now, in most states, this isn't assumed. You have to go in and do the homestead paperwork with your county recorder. It's a little bit of a process, pretty simple usually to fill out. This leaves 400. Okay, wait, let's go back. If you own a piece of real estate that is your primary residence and assessed value is $500,000, you will be exempt from taxation on $25,000 on that assessed value. This leaves $475,000 of value that your property tax will be based on, not the full value of the property, like Steve says. There is no reason to go any further in analyzing the 28-page document that has been done thus so far by Steve. Steve has completely fabricated 2 court citations and made an unsound legal argument using the improper meaning of terms clearly defined by the Florida legislator. Any of you that has been involved with litigation should know that these are fatal mistakes to one's cause. And yes, that I have definitely seen that reviewing these gurus' court cases. Ad valorem taxation. Here is the definition that Steve Emerson presents in his document. According to value, a tax levied on property or an article of commerce in proportion to its value as determined by assessment or appraisal. Ad valorem. According to the value, this he's pulling up Beauvair's. This Latin term is used in commerce in reference to certain duties, called ad valorem duties, which are levied on commodities at certain rates per centum on their value. Here is the exact definition as it appears in Black's Law Dictionary 6th edition on page 51. According to value, a tax imposed on the value of property. Oh, see, there we go. So remember how Alphonse says he's not a taxpayer, and he's not doing commercial business or activity on his property, so therefore, his property isn't taxable. Well, guys, that's not the issue. The issue of property taxes is they're opposing the tax based on the value of your property in their county. The more common ad valorem tax is that imposes by states, counties, and cities on real estate. Ad valorem taxes can, however, be imposed upon personal property. A motor vehicle tax may be imposed upon the value of an automobile and is therefore deductible as a tax. A tax levied on property or an article of commerce in proportion to its value as determined by assessment or appraisal. Duties are either ad valorem or specific. The former, when the duty is laid in the form of a percentage on the value of the property. The latter, where it is imposed as a fixed sum on each article of a class without regards to its value. Alright, so pulling the case cited for the definition in the Black's Law definition, Callaway versus City of Overland Park, we find that the court differentiates an ad valorem tax from an excise tax as so. An ad valorem tax is a tax imposed on the basis of the value of the article or thing taxed. An excise tax is a tax imposed on the performance of an act, the engaging in an occupation, or the enjoyment of a privilege. Although we would like to believe that an ad valorem tax is not imposed on commercial activity, and that this is our way out of property taxes. Oh, I read that wrong. Although we would like to believe that an ad valorem tax is only imposed on commercial activity, and that this is our way out of property taxes, I think you would be hard-pressed to get a judge to agree with you. Return by taxpayer. In his interview, Steve states that a return is required to be filed by the taxpayer before a property tax can be assessed. Steve tells us to go find the statute for our state, and then make a records request to the county requesting a copy of all the returns that you made on the property. Oh, so that's what... Okay, so now I know why Alphonse did what he did in this court case, right? When they respond that they have no records responsive to your request, you've got them by the tail. Remember, that was what Alphonse was trying to get them on. Now, you can prove they're depriving you of your subsistence rights without due process and ready to get on writing a 42 USC 1983 complaint, which never have I seen work with these gurus, to take the county and state for all the property tax they illegally extracted from you, plus treble damages and permanent removal from the tax roll. Jeez, who wouldn't want that, right? Well, folks, when it's too good to be true, it's because it is. Alphonse found 72 PA statute is a Pennsylvania statute that Alphonse found where a return by the taxpayer is required. This is how it starts off. For the purpose of ascertaining the amount of tax payable under this act, every resident liable to pay such tax shall, each year on or before such date as shall be fixed by the Board for the Revision of Taxes or the County Commissioners, transmit to the Board for the Revision of Taxes or the County Commissioners, upon a form prescribed, prepared and furnished by the Board of Revision of Taxes or the County Commissioners, a return certified as provided in this act. Things are looking good, but wait. Let's zoom out and see what chapter this is under. We find that 72 PA statute, subsection 483, 72 PA statute, subsection 4843.1 is under a chapter titled Tax on Credits, Loans, Money, etc. for county and city purposes and their assessment. And there's another there's another chapter titled Real Estate and Personal Property. Starting to see the problem here? Below is a picture of what I found, but feel free to follow the link and see for yourself. So here we go. Here's a screenshot. Tax on credits, loans, money. Okay. You guys getting the idea here? Subjects and rates of county taxation in general. Another return by taxpayer example, Missouri. Someone just shared this link for the return section in the Missouri statutes. Here's what it says. 137340. Taxpayer to file a return listing all tangible personal property. Every person, corporation, partnership, or association subject to taxation under the laws of this state, owning or controlling tangible personal property taxable by any such county, shall file with the assessor of the county an itemized return listing all of the tangible personal property, so owned or controlled on January 1st of each year, together with such additional information as required by the assessor to permit a determination of its value, shall be signed and certified by the taxpayer as being true and complete list of statement of all taxable, tangible, personal property and the estimated true value thereof. So jumping back to the definitions for the chapter in section 13010, we find tangible personal property includes every tangible thing being the subject of ownership or part ownership, whether animate or inanimate. Tangible personal property includes every tangible thing being the subject of ownership or part ownership, whether inanimate or inanimate. All right, so here we go with the definition of tangible. So here we have the definition of tangible personal property. Includes every tangible thing being the subject of ownership or part ownership. Okay, so blah, 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 other than money, because remember, money is non-tangible. That's considered non-tangible property. And not forming part of part or parcel of real property as herein defined, but does not include household goods, furniture, wear and apparel, and articles of personal use, and dormant. Oh, remember how they're trying to use that whole household good thing? As defined by the state's tax commission, owned and used by a person in his home or dwelling place. Now, I'm not going to include the definition of real property at 137.104 because of its length, but feel free to check it out and confirm that a return is not for your real property. This is just 2 states, right? But you're more than likely to find the same in others. Again, these are all uniform by now. The argument fails. All right, so wrapping it up. Now, if you've listened to any or all interviews Steve Emerson did with Angela on Talk Shoe and Bo and Rocco's show, you probably remember there being mentioned that Steve lived in Orlando, Florida. Angela even nicknamed Orlando Steve. You may also recall that Steve worked in aeronautics and that his email Skype starts with NASA help. Now, depending on how much you have woken up to the lies we have been indoctrinated with from birth, the pieces may be coming together. Don't you see, people? You've been fooled by a guy that works for NASA. Has anyone seen any evidence of a property removed from the tax rolls by Steve Emerson? I know Alphonse has stated that he saw the documents that Steve supposedly has under an NDA agreement. Oh, he used that just like all the other gurus. I have an NDA agreement with the court to not show anyone. And then when asked about a case number or caption, it was retorted that all cases are under seal. Sorry, folks, but if a case was filed, there would be a record of its existence, even if the docket was not available. That's exactly right. You see, this is just more evidence that the stories told by Steve Emerson are a myth. And let's remember, people, Alphonse, his claim to fame was, I don't use the Patriot mythology. Well, here we go. And Alphonse is the bigger fool for repeating Steve's make-believe story ad nauseum, and even uses it to support his own credibility, because he knows the guy. Don't be a sucker. Alphonse's early affidavits of status stated he was not a citizen. Now, after he was introduced to Steve Emerson, he proclaims to be a U.S. citizen and that it can't hurt you. All right, guys, so here is an email that was sent out to people interested in the notice of liability. So let's read down here. I'm all about counteracting this kind of stuff, whether we're talking about the health stuff, the 5G radiation, which I'm a big proponent of mitigating. Look, there's a lot of things that you guys should be doing to mitigate radiation, because I hope you are. We can use silver, copper, other things to use to mitigate the 5G. It's official. Empower CEO and co-founder. Oh, wait. Empower CEO. Oh, I thought this was a 508, people. I thought it wasn't a company. Government and corporate officials all over the world have been billed $6 billion. Empower members are setting a blazing pace in the fight against for-profit harm, which, with billing against 4 harmful agendas, jumping almost $1 billion in the space of 1 month. The notice of liability is the catalyst for this. Members select the cause they wish to remedy. Research the governmental and corporate agenda agents responsible, and submit a notice of liability to each, providing them with an opportunity to rethink their contribution to these detrimental endeavors and cease their behavior. Like I was saying earlier, guys, these notices of liabilities are not legally binding unless under court order. And like I said earlier, you can send any company a bill. I can send Costco a bill right now. Does it mean it's going to be collectible? Absolutely not. They're going to throw it away and laugh. If they don't perform, participants start the process of billing and drawing wealth out of the system. Oh, really? Explain how they draw wealth out of the system if you're notice of liability and the bill that you send is not collectible. Never have I seen one person prove that they collected any money from doing this. CDC director resigned after receiving Empower's notice of liability in the mail. Government and corporate officials have stepped down. Oh no, it's not because people retire or change careers or get a new job. No, it's because of us. Guys, this is delusional. We're putting the tail of the snake into his own mouth so that it eats itself. Look, guys, if anyone's the snake here, it's this guy right here. Empower is an uncorporated, non-profit association. Well, remember, guys, in the United States, an association can be considered to be taxed as a corporation if you don't know what you're doing. Operated as a tax-immune, integrated auxiliary business. Oh, so they do say it's a business of Revelation 18 Church, recognized by the United States as a 508c1a designation. Guys, there is no such thing as a 508.
A 508c1a, it's not a structure. It's not an entity or organizational type. It's merely an IRS code. It's a section of the IRS code in clarification for section 501c3. And so a 508c1a, the 508c1a exemptions cannot exist without first being a 501c3 existing. So, and now no true church should use the 508 IRS code as the source of this legal authority anyways. So what is a church? Well, if you're a Christian, hopefully you know it's not an IRS code or documents. It's, of course, the body of Christ. Well, what does the IRS consider a church? Because we need to look through the lens of the IRS and see how they scrutinize an organization to see if they're actually a church or not. And so when the IRS looks into structures that qualify as a legitimate church, they work off our criteria that's called the 14 point criteria. And so the first one is going to be a distinct legal existence. And again, since a 508 is just a subsection of the 501 code, that's not a legal existence. And so it must also be reasonably available to the public. You might want to think about that again. You know, somebody actually shared their EIN letter that they got following the process that the 508 people do. So this is the bottom portion. I'm not going to include the top because of their personal information. But yeah, this is, you know, on the EIN letter that they got after following this supposed 508 process. And so, as you can see, you know, they said, hey, you submitted your application for EIN. You checked the box indicating you are a non-profit organization. Assigning an EIN does not grant tax-exempt status to non-profit organizations. Publication 557, tax-exempt status for your organization, has details on the application process, as well as information on returns you may need to file. To apply for recognition of tax-exempt status, organizations must include or complete an application on one of the following forms. Form 1023, application for recognition of exemption under section 501c3. Where does this say anywhere about, hey, if you're a 508, you're automatically exempt? It doesn't say that anywhere on this letter because, of course, as we know, a 508c1a does not exist as a structure. It does not exist as a nonprofit organization. It's just a subsection, a clarification of section 501c3. And here, I can't disagree with the IRS here. Hate to say it, but they're just following their own code, which anyone can read. So yeah, and so that blows the whole narrative out of the water with these 508 gurus because they tell you Well, if you're a 508c1a, you're automatically exempt. You don't have to apply for a tax exempt status. Here's just some further evidence of, whoever is participating in this 508c1a thing, whether you know it or not, whether, you bought this thing from a guru or you're the guru that's watching this right now, you are perpetuating a fraud, and you are defrauding people that paid for a 508. These poor people, they pay thousands of dollars for a fraudulent set of documents and a fraudulent idea of a PMA. These 508 gurus want to hide this, right? Like how do they expect people to not read this after they get the IN letter? A lot of people don't, but some people have figured it out and they reached out to me and they said, hey, and so I wanted to show you guys, look up human understanding versus United States. And so if you want your organization to be tax exempt, you have to apply to become a 501c3 within 27 months of starting your organization. And so in Universal Life Church, Inc. versus the United States, the court found that the plaintiff's tax exempt status was not legitimate.
The idea that individuals are traded on the stock market is a fundamental misunderstanding of financial markets. CUSIP numbers, which are assigned to securities, those help streamline their identification and settlement transactions, but they have no connection to personal documents like birth certificates, which these gurus and people in the space claim that your birth certificate is made out of security paper and is a security traded in the market, okay? Now, CUSIP numbers are managed by the American Bankers Association. CUSIP numbers are used exclusively for financial instruments like stocks, mutual funds, and even in derivative contracts, okay? And as you can see here, this is just from one of my option contract trades. You can see that there's a CUSIP there. Nowhere does it have to be doing anything with an individual. You are not worth millions of dollars, nor does the system want or need to trade you. They already make all the money collectible through taxes, right? So you're coming up with a scenario where the government would way overcomplicate making money from you, right? It's simple. To be traded in the stock market, you have to be a public ticker, which is quite easy to find, and that reports corporate financial statements the whole market can access. Again, these are very easy to find. Now, I'm going through on this all the different stocks just in the S&P, and I have access to all the other data. There are close to 7,000 tickers in the entire market, and not one of them has any of you as a traded symbol.
I remember wanting to verify that too, because everything was turning out to be a lie.
Yeah.
And I verified that
It's
the
a lie.
United States. Who the hell does the United States declare bankruptcy to? It is the bank,
Right.
first of all.
And so they can't go
right?
bankrupt, yeah.
Right. They can not pay their bills.
Right.
Don't get me wrong.
Default.
And that's happened quite a few. Default is not bankruptcy. Now, there's been one mention of bankruptcy, and that was a colloquialism that was used by the congressman that went, or the senator that went to jail, to can't remember his name, I think it was Chicago, but he said, we're here today managing the largest bankruptcy ever, da, da, da. But it was, when he said bankruptcy, he didn't actually mean, bankrupt is a term that really refers to the personality or the irresponsibility of the person that is bankrupt, not necessarily that the action of bankruptcy. you can be morally bankrupt, is what I'm saying. So,
Right.
which is a lot of what we're dealing with. So, but I just wanted to make that clear that is another mythology. There is no bankruptcy.
Yeah.
Not even states can declare bankruptcy. That's part of the bankruptcy code of the United States. So it just doesn't work that way. The bankruptcy is for corporations of a different sort. That would be, like I said, who would you be appealing to, right? These are the logical kind of things you
Yeah.
have to think about. There's no one to declare bankruptcy to. Now you can get into debt, like so many countries do, to the World Bank and everything, but they're not bankrupt. They're just unable to pay debts. And so they
Right.
they loan money or they borrow money and they give things like water rights away and are screwed for the rest of their, they pretty much have destroyed their people. Well, the thing is, when you can print money arbitrarily, how do you possibly go bankrupt?
Yeah.
They can declare everything. All debts can be declared nullified tomorrow if they wanted to.
Right. And like you said, they are the banks. So how do you
Well,
bankrupt
I
yourself?
showed in my documentaries, I showed they have enough money to pay off all their debts. They just put it into investments. Right.
Yeah.
So the whole thing's just one big fat lie. And I fell for the lie too early on in the game.
Yeah.
So I don't blame people again for believing these things. They kind of sound reasonable until you
Right.
look. But we don't look.
Yeah.
And I gotta tell you, man, for me, I'm almost embarrassed to say that I was a part of the truth movement. I mean, at this point, what it's produced is so far worse than anything the mainstream could have produced, I hate to say that, but geez, what the hell, people?
It's a worse indoctrination, I would say. It's and I first heard about the bankruptcies watching a John Birch Society documentary about it. And so I didn't realize at the time that they were CIA.
It's parrots, and the parrots repeat each other. They don't actually do the research themselves.
Yeah.
I can't tell you how many documentaries have the same thing. There's quotes about the Federal Reserve that are known to be false, and they use them anyway. And I don't know if they know this or what. I mean, it's just, I'll tell you what changed for me. I think I'm glad that I started the way I started, because the first thing I really looked into, thanks to Walter Burian, or the frickin' audits of government, the comprehensive annual financial reports. Man, once you look at the audit, there's no more guesswork. Like, it's all there. Anything you want to know about the Fed, look at the CAFR. They have to print it, because guess what? They're not private.
Yeah, exactly.
They're independent, not private. So all government corporations, and that's everything, have to have a CAFR. So you want to know anything, just go to the audit. They call it the audit. There's the idea of the original United States versus the new imposter United States. United States of America versus United States, which I discovered now it just isn't true. And I explained why that's not true, that it's, again, just a style. And it really is a boring topic when the conspiracy is so much more elaborate than the real thing. The real thing, it's an accounting thing, because the United Nations writes it USA, I think, and the United States writes it US. And so there's two systems of styles that you would write it in, but it has nothing to do with, I don't know, whatever, the 13th Amendment or this or that or that. No, the states were conquered and had to redo their constitutions. The Constitution of the United States didn't change, so it didn't need to, because it became illegitimate anyway. So everything's illegitimate at this point. There is no past or future. It's all illegitimate. So, which is ironically a term that applies to every country. There's always a de facto and a de jure, right? There's always what's lawful and what's not. That's because governments can do lawful things, but everything that's commercial is de jure. It's not part of the purview of a legitimate governance, right? So that's all contract, and that's why the law of contract makes the law.
Implied contracts are legally enforceable promises of mutual assent to be bound. See UCC subsection 1 through 201. Now, implied contract which does not have explicitly stated terms is still found to exist because parties assume the contract existed based on conduct. Alright, so let's go through what's called an implied in fact contract. If a customer accepts services from a merchant or gets products from that merchant, then they should pay for the reasonable value of services or products. However, under some circumstances, even if the defendant has received nothing of value, the implied in fact contract can still be enforced. Implied in law contract, which is sometimes referred to as a quasi-contract. It is not only applied when there is no contract, but also applied when there is a total breach of contract. There are no requirements for the meeting of minds or mutual assent. That's a lot of things goes try to say, well, there was no meeting of the minds, that makes the contract fraudulent. Well, no, here we go. This is an implied in law contract. No requirements for meeting of minds or mutual assent. To imply a quasi-contract as a method of recovery, the measure of recovery is not the contract price, but the reasonable fair value of the benefit conferred.
Start to realize the truth movement is all about creating cognitive dissonance, right? But what is cognitive? It's when you have two conflicting things in your head, right? Two ideas, left and right, completely different, and yet you gotta believe one of them, right? One of them even though it goes against the right answer, you lean towards the wrong answer. Because why? Well, it makes you feel good. The truth that hurts. The truth is not ever pleasant. The truth is a spiritual awakening, and a spiritual awakening is never pleasant because you see what's actually happening. You don't want to see that. You want to live in the matrix. You want to live in the dream. But that's not where truth lies. And so you're in this state. You want to believe so bad that I can be a state national. I want to believe so bad that there's this group of... Okay, if there's one foundational lesson that has to be known for everything that we talk about, whether you're getting a trust and it's being written up by Brandon, and there's one thing about that you've got to know and you got to understand so that you don't have this dissonance. You don't think you've done something when you haven't, or you don't believe in something that isn't true. The foundation of everything, and what really confuses people, I think, is the difference between an action and writing something in words. Okay, just because let's say Brandon makes a trust. He says, I don't got anybody else, so I'm going to leave everything I'm going to leave my estate I'm going to name my beneficiary as Clint. Right? So, I'm sitting here, and now I have a duty. Okay? But I don't have an obligation. It's my action when that is an offer to me that will decide whether I'm the beneficiary. I'm not the beneficiary of anything unless I agree to it. And I act the part. But under no circumstances, how many times do you see in a movie or something, someone goes to a reading of the will not knowing what's going to happen or if they're even a beneficiary or going to get anything, right? That's because there's no requirement for me to you got a crappy old house you leave me, more as a practical joke than anything. I don't have to accept that. A trust does not set anything in stone. It's an evidentiary. And when you do paperwork, as they call it, when you send an affidavit, it's not real. And the worst part, the real cognitive dissonance comes here. I'm sending to government, which is basically a corporation that has employees, and they call those employees citizenships, right? Little vessels that we use in commerce. That's what they have control of. And because we do everything through that person, they control us. So what we do is we send an affidavit or whatever they're telling you to do. Send it to this, send it to the Secretary of State, send it to every state, send it to states you don't even live in. And you say, I'm not the person. I rescind my citizenship. I want nothing to do. Whatever words you're using. sending it to a place that can only deal with citizens and their agents, which are us. And then the next thing you do is you go out and you spend money on your credit card that's in your straw man's name. Or you go out and you use the name, you sign something, you do everything in the name that you just said you are not. While at the same time expecting them to say, well, okay, well, we're just going to forgive you that you're using this vessel, this commercial thing, this person, this status, but then saying you're not it. Okay? Again, you cannot say something is fraud and then benefit from the fraud. You cannot have protection without subjection. You cannot have all. That is not how the system works. So all these letters you're sending, all these things, they are the epitome of what we'd call a cognitive dissonance, because you're not realizing, again, if you send a letter as Christian Clint or whatever, they're not going to be able to do anything with it because they don't own it. It's not their property. Right. You're dealing with the person and then saying you're not the person as the agent. It's totally a confliction of mind, and it's simply because people just aren't grasping that, again, it's your action that defines whether you're in person or not. So when you go spend, when you still have your driver's license, you still have all these things, you are acting the part while saying you're not. That is, you could call that hypocrisy even. It's just like reverse hypocrisy. So, I don't know, this is the problem that we're having and it's a lack of knowledge, obviously. But mostly it's saying you're not something and then acting the part. That is absolutely a dissonance of terms and of thought. It almost makes me want to go and discover, is it a big disinformation op that I was a part of unwittingly? Mm-hmm. Is it just pure ignorance? Is it a combination? Who's behind this? Because it seems to me, like you've said, it's been going on for a long time and we're just the latest parrots to come in, parrot the same thing, but suddenly realize, hey, something's wrong.
So after all of this, I hope you have enough information to deduce whether or not the truth movement is worth being a part of or not. Look, guys, the truth does not need a movement. The truth just is. The truth movement influencers spurred out on debt, bankruptcy, redemption, sham trusts. It's all fake. Literally. Debt and law are artificial, like our friend Clint Richardson has been saying this whole time. What if I told you all of the ways these presenters told the story? Because that's all they are stories. Are sales pitches and marketing. Everything about these stories turn out to be lies, but they do sure stir up emotions. People intake info through emotions primarily, and they know that. The gurus, the show hosts, having these gurus on. But you know what isn't fake? Starting that business that improves the quality of life in your community, or making the numbers in your portfolio bigger. You feel like big, bad Uncle Sam is out to get you, when the whole time, Uncle Sam never gave a fuck about you. You focus on the wrong things, and now you're still dealing with your biggest obstacle to your life goals, your finances. He become the poor that dealeth with a slack hand, but the hand of the diligent maketh rich. Proverbs 10:4.